Thank you for coming to this event, the title of which is Judging the Judges After Transition, the Kenyan Experience. My name is Sujit Choudhry, and I teach here at NYU at the law school, and I also direct the Center for Constitutional Transitions, which is sponsoring this talk and panel discussion. And so let me begin by introducing my fellow panelists. To my left is Justice Albie Sachs, who I think likely needs no introduction in this particular audience, but I will introduce him nonetheless. Justice Sachs was a famous South African advocate for human rights, whose human rights activism began at age 17 in South Africa. When, as a second-year law student at the University of Cape Town, he took part in a Defiance of Unjust Laws campaign. He then attended the Congress of the People at Kliptown, where the Freedom Charter was adopted, a precursor in many ways to the 1993 South African Constitution. He began practice at the Cape Bar at age 21, and the bulk of his work was in the area of social justice, in defending people charged with under racist statutes and repressive security laws. Many of them faced a death sentence. He himself was subject to repression. He was raided by the security police. He was banned in a way that restricted his movement, and he was placed in solitary confinement without trial for 2 prolonged spells of detention. In 1966, he went into exile. He worked for many years teaching law in England. And then he went to Mozambique, where he was a professor and legal researcher. And in 1988, he was the victim of an attempted assassination by South African security agents by a bomb placed in his car. And in that attack, he lost his arm and sight in an eye. During the 1980s, Justice Sachs worked very closely with Oliver Tambo, the leader of the ANC in exile, and he helped draft the organization's code of conduct, as well as its statutes. After recovering from the bomb, he devoted himself full-time to preparations for a new democratic constitution for South Africa. In 1990, he returned home, and he became a member of the Constitutional Committee and the National Executive of the African National Congress, and took an active part in the negotiations that led to the adoption of the 1993 Constitution. He was appointed by President Nelson Mandela to serve on the newly established Constitutional Court in 1994. And he served with distinction on that court for many years, wrote many landmark judgments. And then since stepping down from the court, he has traveled to many countries and been involved extensively internationally, both in a sense promoting and educating colleagues around the world about the South African constitutional experience, the rule of law, human rights, and also through work as an eminent member of the judicial community, and the type of work that he's engaged in Kenya, of course, is part of that. So it's wonderful to have Albie back to the law school. To my right is my colleague, Barry Friedman, who is a Jacob Fuchsberg Professor of Law, also here at NYU, and he has been teaching, litigating, and writing about constitutional law and constitutional issues more generally for a quarter century. And he is a very prominent authority on the courts and the Constitution. He writes and teaches in the area of constitutional law, federal court jurisdiction, criminal procedure, and policing. And his work is very interdisciplinary. He is the author, as many of you will know, of the book, The Will of the People, How Public Opinion Influenced the Supreme Court and Shaped the Meaning of the Constitution, and also on open books, succeeding on exams from the first day of law school. And he is a member or a faculty affiliate of the Center for Constitutional Transitions, and he'll be commenting on Albie's talk when Albie gives his remarks. So just one last kind of piece of introductory information, which is that, so Albie's talk today about the Kenyan experience, in a way is sort of a soft launch for a large international research project that we are participating in at NYU on what to do with judges after transitions. And political transitions, which, as we'll discuss in the panel discussion after Albie's talk, is not a problem confined to Kenya. It's sort of a pervasive problem in many transitional democracies. And this is a project that we are working on with the Bingham Center for the Rule of Law, which is being directed by Jeffrey Jowl. And so Albie's talk is an opportunity, I think, for us to reflect more broadly on the sorts of problems that Albie's going to be discussing in the Kenyan context. We're very fortunate to have him here. And so let me turn it over to Albie. We'll speak for about 30 minutes, and then we'll have a panel discussion and open it up to the floor for Q&A and broader discussion. So Albie.
Good afternoon. Good afternoon.
Good afternoon.
Hi there. Late in 2010, in a very large hall in Nairobi, the chair of the Electoral Commission got up to announce the results of a very hotly contested presidential campaign, part of general elections in Kenya. And he stood up and he said, I'm not giving you exact figures, but it was something like this. Nairobi, Kibaki, 544,399. Odinga, 495,232. Somebody stood up and said, those weren't the figures that I sent in. The officer went on, Nyeri, Kisumu, and one by one other people jumped up and said, those weren't the figures that we sent in. My informant told me that we saw, the way she put it, we saw the elections being stolen on television. The next day, a final tally was announced, and in the evening, without any of the ordinary ceremonies and people attending and the fanfare, almost in secret, the winner declared by the head of the election agency was sworn in. There was mayhem after that. People went out into the streets. Members of one party started attacking members of another party. It extended beyond that. Overwhelmingly, Kibaki, who'd been appointed as president, got support, huge support from the Kikuyu-speaking people in the whole of the central part of Kenya. And his opponent, Odinga, got huge support from the Western Province, Luo-speaking people. But the attacks weren't so much on members of the, from the homelands, as it were, from the heartlands of the Kikuyu speakers and the Luo speakers. It was in the areas where there'd been the most living together, where people were the most interactive, mixed up, living cheek by jowl. And that's where the most vicious attacks took place. And it went on for days. And gangs roamed with pangas, and they burnt down houses, chopped up people, and at the end of this terrible, terrible period, over 1,000 people lay dead. And 500,000 were displaced from their homes. It was a huge shock to Kenya, to Africa, to the world. And the question was asked, but if you saw the elections being stolen on TV and you had slam dunk evidence, why didn't you go to court? Kenya has a judiciary that has buildings, very erudite judges. Why didn't you go to them? And the opposition party that claimed that the elections had been stolen from them said it would have been a total waste of time. No matter how powerful the evidence, how compelling, the judges would have found a way to twist the facts, to twist the law, and to ensure that Kibaki was confirmed as president. The country was in shock. Many people went there to try to find a way forward, a way out of this, and eventually Kofi Annan turned out to be possibly the most successful, and some kind of truce was agreed upon, a compact, an agreement, an understanding was achieved. The Odinga party accepted the notion that half a loaf was better than no bread. It was called the half a loaf solution. And that there would be a government with Kibaki as president, Odinga as prime minister, sharing out seats, and a period for finally drafting a new constitution. I remember saying in Kenya, getting a constitution is very difficult. We spent 6 years on our constitution with breakdowns and rolling mass action and massacres. It wasn't just the wise de Klerk getting together with the wonderful Mandela. It was a very, very rough process, and it took us 6 years. And my Kenyan friend said it took us 20 years. 20 years to get from the one-party state to multi-party democracy, and ups and downs, but lots of downs over many decades. And eventually a new constitution was drafted as Yash Gai, one of the most prominent constitutionalists in Kenya, put it at the induction of the new Supreme Court that I was able to attend. He said normally in many countries it's the political elite who draft a constitution and they put it to the people. He said in Kenya it was the people and community and social organizations that forced the constitution on the political elite. The advantage of that is the constitution is deeply entrenched, it has huge meaning to the people of Kenya generally. The disadvantage is it was left to the political elite to enforce a constitution that they were not enthusiastic about. And one of the clauses in the transitional arrangements in the constitution was to the effect that one of the first acts of the new properly elected parliament would be to establish a body that would interview every single judge and magistrate in office at the time the Constitution came into force to see if he or she was suitable to remain in office, with a subclause saying that the processes followed and the decisions made by that body shall not be questioned in any court. So that's the prologue, if you like, to the presentation I'm going to make. Now I'm going to bring myself into the picture. What's a nice guy like me doing involved in a project like that? And it all starts with the fairly higher position I had in the ICC. You all know the ICC? Do any of you know the ICC? I'm referring to the International Cricket Council. And I was on the Appeals Commission to hear appeals by cricketers who had been fined or suspended from playing cricket for longer or shorter period of time because of some violation of the cricketing code of conduct. And possibly the biggest case that I had to deal with, I was a member of a tribunal, and the tribunal was investigating claims that 3 prominent Pakistani cricketers in the international team had conducted themselves in a way that it's almost impossible to convey to Americans who are not familiar with cricket, but I think you do understand the word fixing. Fixing a game through very deliberate actions at particular times in the game to prove to the News of the World reporter pretending to be a South Asian negotiator for a big betting syndicate, to prove to him that they were honest crooks, and if he paid them a big sum of money, they could be relied upon to deliver the goods. And so they were going to deliberately bowl what are called no balls in cricket in the 5th ball of the 2nd over and the 6th ball of the 7th over at fixed times. And they would do something that would be noticeable just to prove that the man negotiating on their behalf had them under his control and they would deliver the goods. We spent a week on that inquiry. We eventually found the cricketers guilty, and in terms of the code, they were suspended from playing for 5 years, which was the minimum sentence, which for young cricketers, in effect, was to knock them out, more or less knock them out of the game. And the team of the tribunal, apart from myself, it was chaired by Michael Beloff, QC, always Michael Beloff, QC, from London, and Advocate Sharad Rao from Kenya. We became quite friendly. And one day Sharad gets in touch with me and he said, Albie, he is now the chair of the Kenya Judges and Magistrates Vetting Board. And the team of the board includes 3 Kenyan lawyers, 3 Kenyan non-lawyers, and 3 foreign judges. In fact, judges, they say, of some distinction from Commonwealth countries who are going to participate as full members of the board. A friend of mine, Lord Stephen Sedley, a wonderful judge from the Court of Appeal in England, retired, had agreed. He'd helped with the drafting of the regulations, but he waited and waited and waited and waited to get confirmation. It didn't come, so he took up a wonderful position at Oxford that would enable him to write a book on public law, and he dropped out, and now was I willing to, at fairly short notice, to step in, and I said yes. I'd had some contact with Kenya and the judiciary, having been invited about 10 years before that to attend a meeting in which a number of judges and others were considering the establishment of a Truth and Reconciliation Commission in Kenya, and they wanted to hear about South African experience. And I remember sitting in a room about the size of this room, fairly full of judges, mainly almost all men, in dark, somber suits, and there was one person sitting in the front row wearing a T-shirt. And the T-shirt read, "Why hire a judge? Why hire a lawyer when you can bribe a judge?" It's quite a cheeky T-shirt to have. And I might say I bought a copy, one afterwards. I don't wear it very often. And he explained to me afterwards why that NGO was set up. And he said he had a friend who had handled a case in the High Court, an ordinary civil case, nothing political. He won the case. He was feeling very pleased. He walks out afterwards and he hears doof, 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 doof behind him. He turns round and there's the judge running after him. And the judge says, more or less, the Kenyan equivalent, "My good man, why did you go to a lawyer? You should have come straight to me." And that became the basis of why hire a lawyer when you can bribe a judge. So I'd had some indication of the seriousness in Kenya. And I'd heard about what was called the radical surgery in that period, about 7 or 8 years before these elections, in which an authority had been established that published a list of names of judges who were alleged to have taken bribes. Heavy pressure was put on them, and something like half of the judiciary, maybe even more, felt themselves compelled to resign. But the big complaint was they'd been forced to resign in circumstances where their own rights hadn't been respected at all. No charge, no opportunity to challenge. They just read their names in a list, and it was more or less indicated if you leave quietly, you can keep your pensions. If you don't, disaster might befall you. And just a few of them went to court, the cases dragged on for a long time, and they got their positions back. So that was the background. I arrive in Nairobi, there's considerable excitement, some very negative press article about me, which somebody said was a presage of what was going to come, about this strange person, Albie Sachs, who doesn't celebrate birthdays and is very eccentric, and authored the same-sex marriages case in South Africa, and he's the one who's been called in to vet our judges. So it's already part of the atmosphere that's being established. In any event, we get going. I read the Constitution, I read the statutes, and it turns out that the general population in Kenya was absolutely furious, livid with the judges. In some ways more angry with them than with all the other people they felt were failing. Because you feel you expect something different. You know that politicians can be crooked. You know that people run for office and bend the rules all the time. But you expect the judges to hold out, the judges to stand for something that's a little bit different. And so there was a very powerful move to get rid of all of them and only allow people to come back applying one by one. But that was felt to be too drastic. You need something to enable the transition, the courts to be functioning. And extensive meetings were held with the Kenya Magistrates and Judges Association, and a compromise solution was worked out. The compromise solution was to have a vetting board rather than a clean sweep and reapplication. And included in the statute that Parliament adopted were provisions which the judges' organisation asked for. One is that the principles of natural justice should be applied. It wouldn't be like the radical surgery. Another was that hearings should be confidential unless the judge concerned asked for a public hearing. A third was that there should be a limited form of internal review. So although no court could question the decision, no court would do that, there could be review on the basis of new evidence that couldn't have been found at the time of the hearing coming to light, or a patent error on the record. And there was precedent for that limited review in Kenya for that. How to start? We had a structure, we had a statute. The criteria was spelt out in the statute, but we had to decide whether the person was suitable to remain in office. And sometimes the word unsuitable was used. But that's not very, very precise. We were told what factors we ought to look at. And it would be the work record. And we had to take account of, and it's spelt out quite extensively, factors like integrity. And then that was sub-categories of integrity were spelled out. Lack or impartiality. And it's very odd. In Kenya, for some reason, people use the word impartial to say you were doing something wrong. And the accusation would be in a complaint that the judge was impartial. Impartial sounds like not, we're so used to impartial, not impartial, but impartial sounded like you're doing something wrong. Temperament, capacity to apply good sense in a practical way, and even service for the community was included in the factors that we were asked to look at, but very broadly spelled out. The panel of 9, the statute said, could function in terms of panels of 3. That's the board of 9. 1 foreign judge, 1 Kenyan judge, 1 Kenyan lawyer, 1 Kenyan non-lawyer. But we decided early on it would be very dangerous to start in panels of 3. We were so diverse in life experience, in background. There was no precedent we could work with. We had to establish a modality. And I know in my own case, I was very worried that the outcome would be hugely dependent on which 3 people you got. I think at one stage I was seen as the bête noire. So pity on the poor judge who drew Albie Sachs, and not Georgina Wood, maybe, Chief Justice of Ghana, or Fred Chomba, very experienced judicial officer from Zambia, or vice versa. We didn't know how to conduct interviews. We knew we would have Hansards recording the proceedings. We knew that we would have complaints received from the public. But complaints were not like charges and indictment. They would be filtered by assistant counsel that we had, by a panel of our team, and decide these are specific complaints that we would ask the judges to deal with in their responses, and they gave their responses. The judges were also asked, in addition to responding to complaints from the public, to give a wealth declaration, quite extensive. And finally, they were asked to submit, in addition to filling in a very extensive questionnaire, they were asked to send in 4 judgments which they felt, 4 opinions you would say here, they'd written which they felt gave a good indication of the work that they'd done. So we had a huge pile of material to go through in each case, but how to function. And I can still remember the very first judge who came, and we had to work from the top down. The senior judge in the Court of Appeal that had been in the final court, Justice Omolo, big person, he was actually literally physically shaking. It was worrying. And I remember the first question I put to him, I'm not giving away anything deeply confidential. I said, Justice Omolo, I don't know whose heart is beating faster, yours or mine. And I've been sitting on the bench for a long time, but I'd never been judging judges. It's a whole new experience. And I found it emotionally quite difficult, intellectually very, very challenging, and grueling in many ways. Typically, an interview would last 5 or 6 hours. Some went on for several days. The judge could have counsel, and almost invariably had counsel, the right to question any of the witnesses, to call witnesses, and to make a statement at the end of the proceedings. Now let me mention some of the problems that we had. The one was that we had a fairly tight time limit. That's in the nature of transitional arrangements. You have to get through quickly to be transitional. On the other hand, we had to respect natural justice and be fair. But we couldn't have a full proceeding dragging on for days, like O.J. Simpson trial. It just couldn't be like that. How to get that balance right was a central core problem that we had. Secondly, we were obliged to have proceedings in camera, confidential, but everybody was dying to know what's going on. And one of the problems about the judiciary was sometimes they would function at night, far away. People didn't know what was happening. So transparency became part of the very project that we're aiming, the values we're trying to maintain, and yet people don't know what's happening. How could we deal with that? The Constitution seemed very clear. No court challenges at all. There were court challenges. And some of the judges found ways round what seemed to be very, very clear language that no decision or process shall be questioned. And they said the other provisions in the Constitution granting certain rights, why should judges be deprived of their rights? And on a couple of occasions, we were actually stayed by the courts. It was very frustrating, short time limit. And the judges who sometimes themselves were facing being vetted were stopping us from carrying on with the vetting process. And there are articles in the press all the time speaking about kangaroo courts, kangaroo provisions and so on, very, very hurtful, suggesting we're taking money, and it's a country of intrigue and rumor, and nothing in Kenya is taken, or what used to be taken, at face value. So it's not a nice, clean, comfortable context in which to operate, where you just get on with your job and the results come out, and some people are unhappy with the results, but they think maybe we're a bit stupid, or we lent too much this way or that way. People are challenging the very process all the time, one way and another, inside the courts and outside the court. So let me give you some of the outcomes. We decided 4 out of the top 9 judges, who'd been the 9 judges in the Court of Appeal, that was the final court until constitutional amendments came in, were unsuitable. And the first was Justice Omolo. And I think he was taken aback, and it comes through in his review application afterwards. So again, I'm not giving away anything that was confidential. Expecting to be challenged simply on the basis of taking money, there were no serious allegations of that. But he was challenged on his work record, and in particular we were able to pick up on questions put to him at an interview before the Judicial Service Commission, where he stood to be the Chief Justice, a new post created as head of the newly established Supreme Court. And one of the representatives of the legal profession tore into him and asked him to explain decisions that he'd given in an election matter that had been heard about 20 years before. And we investigated that case. We got the opinion that he'd written. So there was no challenging, no questions of fact. And the issue was as follows. A bitterly contested first-time multi-party elections since the one-party state had been established. President Moi was declared to be the winner. Matiba, who'd had huge meetings, very, very popular, challenged the results and said there had been blatant faking, rigging of the elections. He went to the election court that had been properly established, 3 judges from the High Court, and they said we will hear the matter. But before they could hear the matter, there was an appeal from the election court to the Court of Appeal. Now that was in spite of a statute that said election matters cannot be taken on appeal to the Court of Appeal. Very clear, a statute that had been recently passed to prevent exactly this kind of thing from happening and to prevent candidates and winners from spinning out the appeal process for years until the next elections came on. That was being done frequently in Kenya. The Court of Appeal said, but we are not considering the election matter, we're only considering whether or not the petition was validly submitted. And the election law says an election petition shall be signed by the petitioner personally. Matiba had been locked up in prison. He had had a stroke. Some people felt he'd been poisoned. He was paralyzed. And he gave a power of attorney to his wife to sign the petition, and she signed the petition. I could hardly believe my eyes that the Court of Appeal can get round a clear prohibition on hearing appeals in matters like this, taking an ultra-technical point like that, and saying that in those circumstances it wasn't signed personally by him. To me, that was astonishing. The matter didn't stop there. So what they said was, we are not looking at the election matter, we're looking at a procedural point. Then looking at the procedural point, they went into the substance of the complaint, not the jurisdictional matter, and they held unanimously that shall be signed by the petitioner means shall be signed personally, and therefore the petition was out of court, and therefore now the time period had elapsed for making the application, and there could be no challenge. I could hardly believe that. But that was the decision of 3 judges in the Court of Appeal. Justice Amolo then was a fairly young judge, new judge. If he just signed on, I don't know what we might have said, but he chose to write a concurring judgment. And in the concurring judgment, he speaks about President Moi as being a fine person, saying that how can you make these startling allegations where you need proof beyond reasonable doubt, and saying Matiba struck him as being an attention seeker. This is kind of shocking. And he quotes counsel as saying, what would you do if a double amputee stood for election? And he said, what right would a double amputee have standing for election? Now, do you think somebody giving a judgment like that is suitable to remain on the bench? And it didn't stay there, because there were cases, 3 or 4 or 5 cases after that, all of them doing the same thing. It's granting impunity to those in power, twisting the law in ways that go well beyond simply being pro-executive, anti-executive, pro-Republican, anti-Republican, for Bush, against Bush. It's a gross, gross, gross manipulation of the law. And the consequences were terrible, because the next time elections came, people said it's a waste of time going to court. I'll just very quickly run through some of the others. The next one was Bosiri, who had been in charge of the Goldenberg inquiry, commission of inquiry into the looting of 5.8 billion Kenyan shillings, which would have been hundreds of thousands of US dollars, by top officials, government officials, the whole country knew about. And he had the commission of inquiry, and he said there was lots of evidence against a whole range of government officials, but he didn't call them. And he claimed, when we asked him, why didn't you call them, he said, I didn't have the power to do it, but he did have the power. The power was in the statute. What kind of judge is this? Doesn't even understand his own powers. Impunity, impunity, impunity. The next judge, who was also found unsuitable, went the other way. Instead of relying on pure technicalities, he used the Bill of Rights to defend the fundamental rights of one of the persons named in the Goldenberg inquiry as one of the highly likely probable thieves being put on trial, and he gave a permanent stay of prosecution against this person being, Saitoti was his name, being put on trial, quoting the Bill of Rights and saying he wouldn't get a fair trial, and quashing passages that were in the Commission of Inquiry report, which I've also never come across anywhere. You can challenge the procedure and say the procedure wasn't right. I've never heard of challenging actually the accuracy of findings in the Commission of Inquiry report. And he didn't do it just once, but 3, 4, 5 times, and he was called the gatekeeper, who would be appointed by the then Chief Justice in all these sensitive cases. And this is what brought the judiciary into grave disrepute. We got almost no evidence of bribery. People didn't come forward and say, as a patriotic Kenyan, I think it's my duty to say I bribed the judge, I'm willing to go to jail for the sake of the nation and to have the decision in favor of my client set aside. So we only had, and maybe in discussion I can mention some details about that. And in the end, we found that of 4 of the top 9 were unsuitable. We announced it in public. We gave reasons as fully as we could, redacting some names and details. That was the way of combining transparency with confidentiality. And there was jubilation at that stage. But somehow, as more and more people were found unsuitable, it would be a member of someone's church or faith community, or someone they knew, or maybe the tribal group, and there were different alliances of people now complaining about the work that we were doing. And the court was stopping us from time to time as well. Final outcome, the proof of the pudding is in the eating. Elections were held on the 4th of March this year. That's last month. And great tension and uncertainty in the country. Uhuru Kenyatta got 50, it was almost like 50% plus 1. It was plus a couple of thousand. That pushed him over the threshold for being automatically made president without a runoff. What's going to happen? And half the population of Kenya feeling robbed. That he had money, he had the name, he'd grabbed a lot of land, his family had grabbed a lot of land, and now he's sailing in. Would there be a repeat? And Odinga, who's been waiting so patiently, who'd been in jail himself, who'd been trying for years to get transformation in Kenya, went to court. He went to the Supreme Court. He lost the case. He said he accepts the results of the case. My own view is that Odinga might emerge as the great winner of the whole process, as the first prominent Kenyan political person to truly accept constitutionalism. And if that is the outcome, and hopefully it holds, and if the new president respects what's involved and doesn't use his position as president under a new constitution that limits him much, much more than previous presidents found themselves in, then the country really might prosper. Then some of the worst features, the assassinations, the thievery, the nepotism, the tribalism entering into everything, might become something of the past. It was an extraordinary experience for me, a very testing one, a very, very grueling one. This is just a fun holiday for me, giving lectures just about every day in the USA. But I think the Kenyan model, and we've written it up quite extensively, and hopefully the publication will come out quite soon, will become the starting off point for any courses that you might offer and for any other countries that might be envisaging similar processes. Thank you.
So let's begin a bit of discussion with Barry Friedman.
Thank you, Sujit. So it was great to listen to that, and I have several things to say, but I have to confess I say them with a terrific amount of humility. I know generally what anyone knows from the news and the media about Kenya. After getting this assignment from Sujit, did a lot of reading, and so I think I've learned a terrific amount, and I'm glad to have done it. When you read about a situation like in Kenya, you're just sort of overwhelmed with the difficulty of digging out of a hole and making a system work, and how impossible that seems, and also how little from a distance one can say intelligent on the subject. I think what I want to do is offer some thoughts that go to the broader project that Sujit's announcing, the center's working on, about this idea of vetting judges and what you do in transitional systems when you've got a judiciary that is untrusted or was corrupt or just beholden to the old regime. And I'll take just a few minutes, and in the middle of it I'm going to focus particularly on the vetting, because I have to confess, of all the reading I did, all of which was very interesting, nothing was more interesting than reading the judgments from the board. I mean, it was just fascinating to read these discussions about the sort of looking over the careers of these judges. But I think there are a few preliminary things I want to say, and then I'm going to descend into less and less knowledge, and you should trust less what I say until I emerge perhaps on the other end. And I do have some questions for Albie along the way. So the one thing that Albie doesn't say, but when you pick up the literature about Kenya and about the judiciary in Kenya that really strikes me, struck me, is the danger that one has of holding the judiciary accountable for everything that's going wrong in a country. And it brought back memories to me about sort of the transformation in Eastern Europe and the American Bar Association Cecelia project, where American judges would march over to Eastern Europe and explain how to run a democracy and what an independent judiciary should be like. And even knowing much less then than I know now, I sort of held my head and think you can't really believe this, that you're just going to take a system and transpose it on another culture with its own past. And I did read, in a lot of the reading that I did, I had this flavor of sort of, expecting that and it's just interesting to listen to Albie and to listen to him talk about the loss of faith among the Kenyan people in the judiciary and expecting more, because on the one hand, I'm heartened by that, and on the other hand, one can expect far too much of the judges, who are, after all, only human and often operating in authoritarian regimes, and regimes that are corrupt, and regimes in which they're beholden to the executive branch. Most of my life has been spent studying the history of the American judiciary, and I know we all have this sort of image in our heads about that judiciary, and perhaps it's a perfectionist image, but we've often expected too much of our own judiciary, where judges didn't fear for their own skin or for their livelihood or for some of the very basic things in life, and still acted in ways that were completely beholden to the regime and lacked the courage that people expect out of judges. So I think you can only expect so much out of the judges and hold them accountable for so much of what goes on in a regime. Nonetheless, I think it is certainly not too much to ask that the judges not be corrupt participants. I mean, they don't have to be judges, but if they want to be judges, then I think it's fair to have an expectation that they will judge I'm tempted to say impartially, but I guess I've learned a lesson that that's not the right thing to say on this subject. But then I also found from the Kenyan reading that there's this horrible tension that, whatever endeavor the center pursues has to be confronted, which is that as you read the story of what happens in Kenya, and you get to the point where there was the radical surgery that Albie talked about, and you think, so that there's widespread distrust of the judiciary, there's a widespread sense that the judiciary is corrupt and can't be trusted, and so along comes a group of people who do what might be thought to be the right thing, which is to just oust the corrupt judiciary, and yet that sets off its own uproar because people are concerned about judicial independence. So you sort of can't have it either way. I mean, you have corrupt judges, you need to get rid of them, but that will threaten judicial independence for the future. And so how do you navigate that course? And that's what brings us to the remarkable story that Albie tells. So I want to just say a word about the judgments, because if you were to read anything, I would just recommend that you pick up some of these judgments and read them, because they're remarkable. And I can only picture the room with the beating hearts and this idea of judges being held to account. And the question is, how do you hold them to account? And here's just some texture of what struck me from reading those reports. So as I read them, you know, very few of the judges were found to be corrupt in any way. And in fact, the vetting board was very careful to say that it hadn't found corruption. But I didn't know what that meant. I mean, I felt like there was a code going on that I wasn't understanding, because I didn't understand how I could square up the story that I'd read about the Kenyan judiciary with this sense that none of the judges were found to be corrupt. And in fact, this huge respect that was accorded even the judges that were found to be unsuitable in terms of the sense that they delivered long service to the country, that their knowledge should be respected, that some role should be found for them, maybe being let down easily. But still, I wondered how much of what I was reading on the face of the decisions was what was going on, or was simply the best way to explain it. I was also struck by how few incidents there were regarding any judge. You know, these judges had served for a long time. There were widespread complaints about the Kenyan judiciary. I eventually came to put two and two together and understand that these were judges who had survived the radical surgery, so that partly explained, or at least that's my understanding, the nature of the charges against them and what wasn't there. But the decisions about any individual judge turned on very few incidents, and often, you know, complaints about things that happened a long time ago, about particular litigations, about something they'd done in their role as an advocate. And it made me feel like, and again, I'm just deeply curious, that there was this attempt to pick sort of paradigm instances that would shed some light on whether somebody had the most fundamental characteristics that would permit them to go forward as a judge of some integrity, and to just focus on those as a lesson about those judges without trying to pick over an entire record. The most fascinating thing for me, and I just heard Albie do it, and I'm too much the common lawyer and think that there's two sides to everything, was the extent to which the board or the panel, but it was most of the ones, I actually read a lot of them, so it was sometimes three, I don't know whether to call you three judge panels, but three individual panels, or the entire body en banc, but would actually, you know, pick over judgments, opinions, written opinions, and decide whether they were right or not, or whether they were so wrong that you couldn't trust somebody's fundamentals as a judge, which is, you know, almost inconceivable to me, since I spend my entire day doing that about, you know, the justices of the Supreme Court all the time. But it would never occur to somebody to say, well, Friedman says this is completely way out from Mars, so you're not suitable for the job, though I might think that. And so I found that quite extraordinary as a task, and wondered what that was like to do. And so, you know, I'd love to hear almost more about the judgments themselves. There's one last thing I want to say, because this is a caution, I guess, I feel whenever I learn about the situation in a transitional country, which is the danger of going too far and having to adjust. And so I'm not sure I understand the judicial selection system entirely in Kenya now, but I do understand that it went from a system in which the judges were chosen by a body that was extremely beholden to the executive. And there was no faith that the people that were being chosen would be anything other than judges beholden to the judiciary. And it might have then evolved to, and here's where I'm unclear, a system in which, I know it was proposed, but I'm just not sure where it landed, the judiciary is perpetuating itself, which is true in any number of countries. And I particularly believe that's a terrible system, particularly for constitutional judges, for judges that are going to be operating in a constitutional framework rather than just deciding specific cases without constitutional inquiry. And, you know, it's tricky to know what to do about that, because it seems in the first instance like the safest thing you can do about protecting the judiciary, but I'm not sure in the long run it's the right one. So, collection of thoughts.
So let me just add a few more thoughts for Albie, and also for more general discussion. And so the Kenyan story is completely fascinating, and I think the fascination turns in large part for me on what was at stake in the vetting process. And so, you know, there's an interesting, I think, ambiguity over what motivated this process, at least from my perspective. And so, you know, so Albie, when he opened up his remarks and talked about the very preliminary stages of this process, he mentioned corruption, he mentioned bribery, he talked about crooked judges. And so really the vetting process was kind of an anti-corruption measure. That's one way to understand this. But another way to understand these vetting processes is as a technique to get at the problem of a partisan or partial judiciary in the context of a constitutional transition, which is a slightly different problem. And so the problem, and these two problems might coexist in many real-life situations, and they might reinforce each other, right? And so the partisan leanings of a judiciary might be underpinned by corruption. It might be that what gives the governing party or the executive leverage over judges is their corrupt character. But they aren't necessarily the same thing, right? They aren't necessarily the same thing. And so, and the reason why I think it's important to try to push those two apart, even if in fact they are tightly interrelated in any particular case, is that it helps to reframe what's at stake in the Kenyan story, and how we might, with what other cases we might group it, and how we might understand it, right? And so you recall that the vetting process that Albie participated in arose in the context of this very disputed election between Kibaki and Odinga, and where one of the issues of cleavage, or partisan cleavage, was the idea or the claim that the judiciary could not be trusted because it was allied with the governing regime. And so an element to this, to the political roadmap and constitutional transition that came out of that moment was a process to vet the judiciary. And so the argument then had to be that not just that the judiciary was corrupt, but also that it was somehow allied in a way with one side in this political struggle and couldn't be trusted to kind of impartially and fairly adjudicate future cases with a political character to them. And so if that's the way to understand what was at stake in the Kenyan context, then the Kenyan situation isn't really all that unique, right? It's sort of a more, it's an instance and a very high profile and recent example of a much more general phenomenon of what to do when you have a constitutional transition of some sort and you have an old guard judiciary who is in some way identified with the old regime and the old constitutional order. And you have kind of a rule of law dilemma, right? And the dilemma is this. On the one hand, if you kind of engage in radical surgery and get rid of the judges, that might be the best way to ensure the success of the new regime, to ensure that the regime takes. Because if you don't do that, the judges might undermine the regime from within. But on the other hand, by engaging in that type of radical surgery, one might send the message that what matters more than the law and institutions, which by themselves are meant to be impartial and above and beyond any one individual, instead of sending that message, one might send the exact opposite message, that what matters are the particular occupants of judicial office. And so one might undermine the rule of law and constitutionalism in the course of trying to build it. And so if you frame the dilemma that way, Kenya is the latest example of a series of countries that have grappled with this type of rule of law dilemma. So after the Second World War, in West Germany and Italy, the question of what to do with old guard judiciaries, or in France, in Vichy France, was an issue. In the course of the third wave of democratization in Greece, in Spain, in Argentina, and Chile, this question of what to do with old guard judiciaries in the context of democratic transition arose. In Central and Eastern Europe, as has been mentioned by Barry and others, and also more recently in Sub-Saharan Africa and South Africa, at some level this was a point that was debated. Kenya, Nigeria, in South Asia, and Nepal and the Maldives, what to do with existing judiciaries has been debated. And of course in the Middle East right now, in Egypt, Tunisia, Libya, and in other transitional states, the question of what to do with judiciaries that were allied in some way with the old guard regime was kind of is very much a live issue. And so I think the benefit of placing the Kenyan case in a broader comparative context is the following: that if one looks at those other jurisdictions that have grappled with a similar issue, there's a broad menu of policy options that have been deployed by actors, not in any kind of systematic or way that is kind of organized in a policy framework, but is nonetheless interesting. And so vetting is one example that Albie talks about, but you can imagine others, right? So purges and dismissal, and then kind of lifetime bans on holding judicial office, a vetting process like in Kenya, reapplication processes where old judges compete with new judges, truth commissions to investigate abuses, the establishment of new constitutional courts to oversee existing judiciaries, and then in some jurisdictions the use of external judges, right? So international judges like in Bosnia and elsewhere, and as actually was provided for in Kenya, although I'm not sure in the end whether an external judge was appointed to the Supreme Court. And so the question that I have for Albie is kind of a counterfactual, which is that given that vetting is not the only mechanism available to address this type of horrible rule of law dilemma, based on your experience in working the gears of this system, was vetting the right approach? Would any one of a number of these other options, which have been used in other jurisdictions, perhaps have been, attractive alternatives? And in particular, I'm looking to you as a member of the first South African Constitutional Court, where the decision was taken to create the super court that would oversee the whole judiciary. Would that perhaps have been an alternative mechanism available in Kenya? Would that it might have worked better, and so forth? So that's kind of those are my comments and questions arising out of Albie's talk. So Albie, maybe you want to begin, and then we'll open it up to Q&A, and we'll take it from there.
Yes, if I can answer that last one straight away, answer is no.
Yeah.
Clearly no. Yeah. And I suppose what was so dramatic for me was discovering impunity. We had racism, authoritarianism in South Africa, and the courts were heavily implicated in that. But we didn't have that network of impunity. It's like in Argentine, the horrible buzzword was desaparecidos, disappearances. In Kenya, the plague was impunity. And impunity came from what Yash Gai called the criminal state, where it's not a state that is penetrated by corruption, but the state, he said, in other parts of the world, a bourgeois class accumulating capital became quite powerful and then found the state useful for wars and colonial enterprises and so on, and captured the state. In Kenya, it was the other way around. People got into the state to accumulate. They didn't have much money. They got into the state, and the state became a rogue state in that sense. Not rogue in the international sense, but internally. And that provided for a network of impunity. And the judges were part and parcel of that caste who were participating directly or indirectly. So it wasn't simply being pro-Republican or leaning this way or pro-executive. It was profound, and it produced a total cynicism in the society. And the whole constitutional project wouldn't work if people felt that there wasn't somebody there that would be ensuring that all these hard-won freedoms in the new constitution would be upheld. There was like jubilation, and the effect of the four who were held to be not suitable, it was the first time powerful figures had been toppled. It had never happened since Kenyatta, since independence. And that signaled a new Kenya. At the same time, a completely new Supreme Court was established, a new Judicial Service Commission. Before, the President would choose somebody and send their name for formal ratification to the Judicial Service Commission. Everybody knew that. Now they had real inquiries, and the President had to accept, and in the case of the Supreme Court, Parliament had to choose. The big battle was over who would be the Chief Justice, and William Atunga was chosen, and there were two big arguments against him. One was that he had a little earring, and that featured very, very powerfully. How can you have a Chief Justice with a little stud in his ear? And the other was he'd never been a judge. The strongest argument in his favor was that he'd never been a judge. He'd been a law professor, he'd been imprisoned, he'd been part of what they call the Second Liberation. So he was appointed Chief Justice. A strong new Supreme Court was established. The Judicial Service Commission became truly independent. That's choosing judges properly. And they managed to get 2.5 times the budget they'd got before. And so our vetting process was just part and parcel, and I think this is a very important aspect of transitional justice. It's not on its own. You're not going to get, simply by having a vetting process, clearing out what are called the bad eggs. It's got to be part of a much wider process of transformation and change. And also the text of the Constitution, expressly stating, I've never seen a Constitution that says the judges shall not give undue weight to procedural technicalities. It's in the Constitution because of the laws and so on. The people are very proud of the fact that this is our Constitution. The vetting board is seen as an expression of the sovereignty of the people, not some agency set up by the new regime to deal with the opponents in the past. The revolution, in a way, was created through the Constitution. It wasn't, there was a revolution and a constitution came afterwards to deal with the past. So I think one has to really get into that culture of impunity to understand the true nature of the process. The word corruption was used specifically for money changing hands. It wasn't just money, it was like a club, or a cartel of senior public officials all defending each other. And I'm used to being for the defense. And, you know, here's a colleague, 35 years, been laboring all this time, doing a lot of good work. That's why we had this little soft landing sort of at the end. Don't write them off. That's a South African experience. Don't destroy people, whatever they might have done. Try and find a place and a space for them, even if they can't continue doing what they were doing before. But I felt so indignant when I read judges doing this kind of a thing. And it's not simply being conservative. You know, all Americans that I discussed this with immediately start mentioning names on your Supreme Court and say none of them would survive. It's not that kind of debate and argument at all. It's a completely different one.
So, questions? Yep, in the back, please.
Could you go back to the questions of the judiciary self-perpetuating itself?
So the issue of judicial self-perpetuation. You
Yeah, this might be my fault, Albie. I wasn't understanding how the Judicial Selection Commission is operating now. Who's picking the judges?
No, it was a combined thing, and mainly the last point that Sujit made, and things that I'm getting from people here. Whereas in many other countries, when I was in Indonesia some years back, a group that was a meeting set up by the World Bank, I was astonished at the stories I heard about the judges. To become a judge, you had to pay a huge bribe. And the only way you could repay over a period of time was to be bribed yourself. And I was told there's one of the good judges in one of the big areas, you know, was still paying off. And the counsel in the Supreme Court, who had the biggest practice, he didn't say, I went to Oxford or NYU or whatever. He said, I've got the telephone numbers of every judge on the court. So the cynicism was so deep there that it was just hopeless to think of the courts as a remedy. And the theme we used was restoring public confidence in the judiciary. That was the criterion, against the background of the carnage after the previous elections. And it wasn't your usual impeachment, misconduct by an individual judge. It was the kind of conduct that really destroyed the credibility of the judiciary generally, that was endemic, entrenched, and flagrant.
You alluded to how the Kenyan experience is
I think the criteria we built in were quite important. We actually used the phrase when we started off, we don't want a witch hunt and we don't want a whitewash. But there's a lot of space in between those two. I think the 3 foreign judges were absolutely vital. And I know we played a very big role, some of which comes out, but often you don't know. And I would even have a greater proportion, if that's possible. We don't have an axe to grind, and we're not implicated in the internal politics. Of course, we have to be chosen quite carefully ourselves. I think that would be a counterweight. In our case, again, I would say the new government in general was not enthusiastic about the board. So we weren't getting terrific cooperation from very important figures because they were still protecting to quite a large extent. So it really wasn't a case of the new regime finding the mechanisms to penalize the old. But when one thinks of an example now in Egypt, I don't know anything about the specifics. I have met some of their top judges there. But they were appointed under Mubarak. They are not just passing little decisions that are inconvenient, but they're striking down the very constitution-making process in spades. I don't know if there's a basis for doing it or not. But if you don't trust them, because they are who they are, because they've just sided all the time with the old regime, then people are going to go out into the streets, and there's going to be disrespect, for their decisions, and that creates new institutional crises. What do you do when there's a dilemma? You can evade the dilemma and say it's just too damn difficult, or you grasp the dilemma. And I think the only thing is to grasp it, and to be upfront, and to deal with the problems that Sujit has mentioned. They are very, very real problems, to get as much public involvement and discussion, to get the profession involved in that debate.
Philip.
Just one little point to follow up on what you said. The radical surgery, in fact, failed partly because there were no foreigners involved in it, and those who were appointed then captured the process, and most of the judges who were actually dismissed were among the good ones, and those who were confirmed were among the most corrupt. But I just wanted to go back and pick up one point that it relates to Sujit's comment in a sense about the relationship between political power and corruption as the motivating factor. In fact, in Kenya, the impunity relied much more upon the prosecution than on the judges. So, for example, the Attorney General who was in office from 1991 and was under the then
we maybe take
Sure.
other questions on?
Sure.
Justice Sachs, my name is Sherry Meyerhofer, and we met in Kathmandu about 3 or 4 years ago.
Oh, okay.
And at that time, I'm pretty sure I was employed by the Union Bar Association with a partnership with the Nepal Bar Association. And I gave you a presentation or sort of a summary of what was happening and what was being proposed by the bar and other members of the legal profession with respect to what to do with the judiciary. And at that time, we would have told you that the bar and other players were in favor of reappointment. So there would be 2 processes. One would be reappointment. They would look at everyone who was sitting and do some kind of review and reappoint, and then there would be the appointment of new judges to new courts. And that seemed to be fairly settled, as were all the issues of judiciary in Nepal at that time. But at the last minute, in May of 2012, when it became at the political level and deciding what would go forward if there was to be a constitution in that moment, which, as we all know, there wasn't. The political powers, the elites, decided that there would be no reappointment vetting of any kind. It would all be those who were sitting would sit, and there would be no appointments. So my kind of question is what compelling argument can be made, to the elite in power? I mean, those, as you said, the ones you found unsuitable in Kenya were those who were granting impunity to those in power. But it's those who are in power at the end of the day who are going to put in that new constitution, who are going to be deciding what goes into that new constitution, what kind of procedures are going to be in there. So what compelling argument can you give to those people to support some kind of process, be it vetting in the manner in Kenya, or even a review, or any of the other procedures that Sujit had mentioned?
And why don't we take one more, sir?
You indicated a certain amount of optimism about the rule of law after it got accepted in the Supreme Court after the last election. I wonder what your thoughts are. We also met a few months ago in Nairobi last summer, and one of the issues that seems to be in the new constitution, enormous promise of access to justice, which is fundamental to the rule of law, right to counsel, and yet no counsels being, as far as I understood, no counsels even being appointed in death penalty cases, let alone in civil cases. Given the kind of current dynamic, what do you think the prospects of actually realizing the potential of what seems to be a wonderful constitution on paper, but not a whole lot going on the ground to implement it? You think we're going to actually now see something, get traction and changes take place?
Well, 2 things have come through very strongly to me on this occasion. One is the importance of getting our literature out, because it's a very rich text. And so I would say in Nepal, just read the whole thing to get the story and the problems that we had and the decisions that we took. And we should have got it out before, but sometimes funny things happen in Kenya. And you're working through the night and working over weekends, and we got 2 specialists in. One was the son of Ngugi, the writer, who was actually working on the text, and somebody else had been one of the drafters of the Constitution. They did terrific work. And then the whole thing stalls. And then there's the elections and the new president. They want to present it to the new president, and I don't know. So I think anybody who's really interested, and we worked very, very hard on producing a report that's not just a report to our president, a report for the world, realizing this is a unique process, very fascinating, interesting material, and it's got to be made more widely available. I'm not sure what the other thing was that stood out. But I can mention in reply to the last question, I saw a dramatic change in Kenya in the judiciary in the year that I was there. It's visible, it's tangible. And it started with the appointment of William Matunga as Chief Justice. Important symbolically, but he's smart, he's been around the block a few times. He's actually a brilliant legal thinker. He's not a charismatic speaker. He's a good speaker, he writes very, very well. and that was important. The other people appointed were important, and some of them were old guard. But what distinguished them, this one in particular, was that he was very reflective on the role that he played before. And he acknowledged that there had been serious defects. And he didn't feel he was doing it out of opportunism. You don't want opportunists who are now belly crawling because it's a new authority and so on. He was really deeply reflective, even on his own position. And he'd also passed judgments along the way that showed already there was an evolution in his approach. And I understand he's playing a very important role on the new Constitutional Court because he is experienced. So he can help Willie, who was never on the court but has a freshness and a clarity and a principled approach, with the technical things about how you write a judgment and how you deal with arguments and so on. And I think that's working quite well. The other thing is that there's a brilliant new registrar, Gladys Bosch-Cholet, who doesn't get all that amount of credit, but she's in charge of the administration of the courts. And Napoleon said an army marches on its stomach. A judiciary, to some extent, marches on its resources. And part of the background to the corruption, the miserable salaries, the horrible conditions in which people work, the lack of morale generally. And the only thing you had was your mystique, your arrogance, your power, your authoritarian relationship with the people, and then the chance to make a lot of money on the side. And now it's changing. And some of the new young judges are doing terrific work. There was another Ngugi from Seattle writing, and he's now head of the Judicial Training Institute. I don't want to single out individuals, but I've just singled out one, David Majanja, who's doing a lot of work in the High Court. And it's a new kind of gatekeeping. Instead of putting the most corrupt people in charge, it's actually the most intelligent, the most persuasive, the most independent, the most honest. And couple that with the fact that you've now got toilets, and you can now, simple little thing, you can get a loan on good rates as a judge, as something that makes you feel that you are appreciated. And the magistrates are now being better paid, and the conditions are getting better, and they're getting rid of the rats that are chewing up their old things. They're getting computers, they're getting law clerks, they're getting typists to type up the old judgments. There's a totally new energy in the judiciary. And if the judiciary can function well, then it gives hope that the Constitution will be applied. And when I expressed that confidence, it wasn't based simply on they've given the judgment. It's based on the growth and the strength of the judiciary, and it's the public response. Willie has come in for such a broadside from his old pals, his supporters, his gang, if you like. They feel he's betrayed the struggle, he's allowed Uhuru to be elected and so on, and it's very tough and very painful, very, very painful. I'm sure it is for him. He's just got to keep his chin up and understand that goes with the territory if you want to be independent, and other people must learn. He's upheld Uhuru, maybe not his natural person that he would support. It's almost like a Chief Justice who was appointed by Democrats upholding the appointment of Bush, who would be ideologically completely on the other side, very unpopular with his circle of friends and so on, but because the Constitution actually requires that. And that might be the beginning of something quite significant. In terms of the promise that the Constitution holds, they've appointed a new special group of judges to deal with land questions and the environment. Not very well trained. We pointed that out in our inquiries. But the theme of working for the marginalized, for the despised and rejected, runs right through the Constitution. And some discussions I'd been having with judges there on a very informal basis was to emphasize the rule of law as an emancipatory notion. The rule of law is normally projected as protecting foreign investment and coupled with good governance. And that leads to economic growth, which leads to benefits for everybody. I'm not against that, that's fine. And if it serves that purpose, fine. But that narrows the notion of the rule of law to really the rule of lawyers, speaking a coded language amongst themselves, and it leaves out the people who most need the law. And it's those who are being evicted without any process at all. It's people who are beaten up in the home without any process at all. It's workers who can't get any remedy for abuse by the employers. A whole range of groupings in Kenyan society. It means the Somali community or other communities that have never been dominant communities now get a place in the sun. Although one of my friends pointed out there's too much sun there, so they now get a place in the shade. And the judiciary can play a very, very important role. Now, I know I'm an enthusiast as a relatively late convert to judicial authority based on South African experience, but I can see them doing something similar to what the Indian Supreme Court did in the 70s and 80s, when the other agencies of government were failing to fulfill the promise of the Constitution because of corruption and whatever it was. The judiciary picked up the ball, and the judiciary ran with it and gave a new level of inspiration and excitement in society, a quality of hope. And I do see the judiciary possibly playing that role. On the other hand, crashing down to reality, when Willie Matunga summoned judges before the last elections to say he'd received death threats, and when he wanted to leave the country to attend a conference, an official stopped him because he didn't have the permission of the president. That was the old way of doing things. He was very indignant, and he summoned his colleagues, and they listened, and the first hand that went up was, that's very interesting, but what about our motor cars? And I think what about our motor cars could be the death knell, not the overt corruption, but the technicism and the narrow vision of the role of the judiciary, that could be very damaging.
Let me take last question. Katie.
Yes, I'm wondering about how you evaluate judges who are arguing that, yes, I made decisions that were favorable to the regime or that were corrupt, but because I was afraid of retribution or afraid of physical violence. I'm thinking of Zimbabwe in particular.
Yeah.
At least one judge I know of was forced to flee the country after making a ruling that was too independent for his various states. How do you factor that into your decision?
Well, we didn't have that. If we did have that and we felt it was credible, then that wouldn't mean that they were not suitable to carry on, and that, you know, the public wouldn't have confidence if they stayed on. But they defended what they did. They said they were simply carrying out the law. And there was a total lack of insight. There were some others, particularly this Judge Nyamu, who could write quite brilliantly, very flowery language, using the Bill of Rights to stop search and seizure by the anti-corruption agencies, to permanent stays of prosecution and so on. And he didn't do it on his own, but the people working with him afterwards had given quite good judgments to show the independence. And they said, you know, looking back now, we're not proud of what we did. So it wasn't terror in that sense. It wasn't terror. I would say, though, that you don't do something, you leave the bench. And people went to jail, people fought, people struggled for democracy, and they were respected for doing that. So it's not as though there was actually a pistol to your head. You know, duress is something that I think is the very, very, very last thing that a judge who's got, relatively speaking, more autonomy and more protection than anybody else can rely on. We did have one judge who said he signed a contract that gave him an important position in a company that got public property, very rich, important public property, because the person coming into his office had a gun sticking out of his back pocket. I didn't sit in on that case, but the feeling was from the board that it was highly unlikely that happened. And when the gun went out of his office and things were changing in Kenya, he could have repudiated the whole transaction. He didn't do that. That was the closest we got to the scenario that you're mentioning.
Well, Albie, it's wonderful to have you back. You've been an old friend of mine for many years, and also you're an old friend of this law school. And we're very appreciative that you took the time to share your experiences and reflections with us on the Kenyan experience. Thank you so much.